My Lords, Amendment 15 seeks to include the EU Charter of Fundamental Rights as part of retained EU law, with the exception of the preamble and Chapter 5. The preamble contains no substantive provisions, and Chapter 5 confers rights such as the right to vote and the right to stand as a candidate in elections to the European Parliament, which plainly have no application once the United Kingdom leaves the European Union. Noble Lords will know that the Charter sets out a number of important legal rights, from the rights of the child, Article 24, to the rights of the elderly, Article 25. It recognises the rights of persons with disabilities, Article 26, the right to health care, Article 35, and the protection of the environment, Article 37. My Lords, there are three reasons why I commend this amendment to the House. The first reason is that the government's purpose in bringing forward this bill has been made very clear from the outset. The Prime Minister wrote in the foreword to the White Paper that this bill seeks to repeal the European Communities Act 1972 on exit day and to convert into our law the body of EU law which applies as at that date. Amendments to the body of retained EU law are for another day. As the Prime Minister said in the White Paper, I quote, "The same rules and laws will apply on the day after exit as on the day before," unquote. And the reason for that is a very powerful reason. As the Prime Minister and her ministers have repeatedly explained, it is to ensure certainty and to ensure continuity as at exit date. That has remained the government's general position in relation to this bill. On the 11th and final day of committee stage of this bill, the noble and learned Lord Keane, made the same point. The noble Lord said, it was the 28th of March, Hansard column 876, I quote, "The government have always said that this bill is not the place for radical policy change," unquote. I agree. Clause 5(4) of the bill conflicts with, indeed it frustrates, that central purpose of the bill. Clause 5(4) would exclude part, and an important part, of existing law from the law which applies as at exit date. In doing so, it would cause precisely that lack of certainty, that lack of continuity, which the bill is designed to avoid. Clause 5(5) would add to the uncertainty, because what it says is that although charter rights will not be part of retained EU law, fundamental rights and principles which exist in EU law irrespective of the Charter will be retained. This is quite simply a recipe for confusion, especially when there are judgments of the European Court of Justice which will become part of retained EU law on or after exit date, which judgments themselves rely on charter rights. Can I give your lordships one example, practical example, of the problems this is going to pose? And the example is the case brought by Philip Morris, the tobacco company. They challenged restrictions on tobacco labelling and packaging. The Court of Justice in Luxembourg, in its judgment dated the 4th of May 2016, relied, in dismissing the claim by Philip Morris, relied on Article 35 of the Charter, which confers a right to a high level of human health protection in EU law, an absolutely fundamentally important right. As that case demonstrates, one of the purposes of this Charter is to provide a guide to the human rights principles which should inform the interpretation of the body of EU law. If Clause 5 remains in its present terms, good luck to British judges in future cases who will not be able to refer to Article 35 of the Charter, but will be asked by parties to infer such a principle of a high level of human health protection from other EU legislation and case law, and will then be asked to use that principle to interpret other provisions of retained EU law. My Lords, this is not going to promote legal certainty, though it will be very good for lawyers. The legal position will be even more complex, because Schedule 1, paragraph 3(1), which is the subject of Amendment 19 in this group, says that although the principles of EU law, the general principles, will be part of retained EU law, no right of action can be based on them. Amendment 19 seeks to remove paragraph 3 of Schedule 1 because it is simply unacceptable and unprincipled to recognise rights but then to deny a remedy if the principles are breached. So the first reason why I commend this amendment to the House is that the exclusion of the Charter conflicts with the central purpose of this bill to read across EU law rights as at exit date, to ensure continuity and to avoid legal uncertainty. My Lords, the second reason why I commend this amendment to the House is that the exclusion of Charter rights from the scope of retained EU law will have a detrimental effect on the content of our law. During our committee stage debates, the government have presented two mutually inconsistent arguments. They have said both that the provisions of the Charter do not need to be retained because they can be found elsewhere in retained EU law, and they've also said that to read across the Charter would do immense damage to our law. Well, they can't have it both ways. The much-respected Bingham Centre for the Rule of Law published a report on this bill on the 21st of February, and at paragraph 127 they said, I quote, "It is clear beyond doubt that non-retention of the Charter will lead to a loss of the current level of rights protection available to individuals and businesses under EU law." End of quote. My Lords, I also commend to the House a valuable opinion, published opinion on this subject by Jason Coppell, Queen's Counsel, for the Equality and Human Rights Commission, explaining that the Charter has created valuable new rights. And in any event, as Mr Coppell explains, this Charter is important because it states in simple terms the rights which EU law seeks to protect. Without this Charter, there will be considerable legal uncertainty because litigants and their lawyers will need to identify these rights not from a statement such as the Charter, but by seeking to construct the rights from the mass of retained EU legislation and case law, and then use the principles they contain as aids to construction. My Lord, since this is report stage, let me report on the concerns about the inclusion of the Charter in retained EU law which were raised during committee stage. It was said that the concepts in the Charter are vague. They will need judicial interpretation. But, my lords, that is true of the vast majority of retained EU law which this bill is going to read across into our law. EU law is not drafted with the precision which characterises the work of our parliamentary draftsmen. EU law tends to be drafted in the form of general principles which do require judicial elaboration. So this is no basis for distinguishing the Charter from all other retained EU law. Concern has also been expressed that Charter rights might be used to overturn statutes enacted before exit day. But that is what the bill allows in relation to the whole body of retained EU law. The retained EU law under this bill is given priority over statutes enacted before exit day. That's what Clause 5.2 says. It says that the principle of supremacy of EU law continues to apply in relation to statutes and other enactments passed or made before exit day. I emphasise that Amendment 15 is not going to confer on the Charter any greater legal effect than it already has, and has had for a decade. It will not give Charter rights any effect in those parts of our law which are distinct from EU law. My lords, there's a third and final reason why I commend this amendment to the House, and it is this. I fear that the government has a very bad reason for making an exception in this bill for rights under the Charter. I fear that the government is seeking to make an exception for rights under the Charter because the government is suspicious of the very concept of fundamental rights. Yeah. And, my lords, I am puzzled as to which of the rights protected by the Charter, to which of the rights protected under the Charter, the government takes exception. Is it the freedom to conduct a business? Is it the rights of the child, the rights of the elderly, the rights of persons with disabilities, protection of the environment, protection of consumers? Or is it that the government is concerned about court decisions, ECJ decisions applying the Charter? If so, which decisions? Because the government has not come forward to identify any decisions relating to the Charter to which it takes exception. So I ask the Minister, please explain what is the fuss about? And I ask that question because I suspect that the government's concern is purely doctrinal. And I ask this House to say to the government that this bill should not be used as an excuse to reduce the legal rights which we all enjoy against the state. Your Lordship's Constitution Committee, of which I am a member, criticised the approach adopted in Clause 5.4 and 5.5. The criticism is in paragraph 119 of our report on the bill, which is HL paper 69. We said this, I quote, "If, as the government suggests, the Charter of Fundamental Rights adds nothing to the content of EU law which is being retained, we do not understand why an exception needs to be made for it. If, however, the Charter does add value, then legal continuity suggests that the bill should not make substantive changes to the law which applies immediately after exit day." That's the end of the quote. And we added, the Constitution Committee added at paragraph 120 that the approach taken in this bill, we exclude Charter rights, we retain general principles, and then we prevent causes of action based on those principles, that approach, I quote, risks causing legal confusion in a context where clarity is needed, unquote. My Lords, the exclusion of the Charter of Fundamental Rights from this bill is unprincipled and it is unjustified. I beg to move. It's been a powerful debate. It's been a passionate debate. Can I thank all noble lords who have spoken, whether they've supported Amendment 15 or whether they've opposed it. Can I, in particular, thank the noble and learned Lord, the Minister, even though he thinks I lack, what was it, the delicacy of touch, which is appropriate in these circumstances. I'm going to go away and work on it. Can I attempt very briefly, because we've had a long debate, just to try to answer the main points that have been made against this amendment. The noble and learned Lord Brown of Eton under Haywood, and indeed the noble and learned Lord Mackay of Clashfern, expressed concern that the Charter of Rights will enable courts to strike down legislation. And Lord Howarth expressed a similar concern. What about parliamentary democracy was his theme. And the noble Lord the Minister put his case very high. He said it was shocking. It's a constitutional outrage that we should be bound after exit by a body of foreign law. Well, I have to ask him to read his own bill, because under this bill, if a statute enacted before exit day is inconsistent with any part of retained EU law, the statute gives way. It's the supremacy of retained EU law. See Clause 5(2). So a concern about parliamentary sovereignty is no basis for excluding the EU Charter of Fundamental Rights from retained EU law. Legislation that is enacted after exit date will take priority over all retained EU law, which, if this amendment is passed, will include the Charter. And that is how the bill asserts the sovereignty of Parliament, together with Clause 7. So this is a complete red herring. Amendment 15 has nothing whatsoever to do with the sovereignty of Parliament. This bill deals with the sovereignty of Parliament and deals with it in a perfectly acceptable way. It maintains the sovereignty of Parliament. We can do what we like after exit day, whether or not Amendment 15 is approved. Baroness Deitch criticised the drafting of this charter. But in the context of a bill that is designed to secure legal continuity on exit day, it cannot be right for noble lords to point to individual provisions in the Charter which they don't like or which are poorly drafted. And the reason for that is that noble lords could carry out the same exercise on every regulation, on every directive, which is to be part of retained EU law and is being read across. Again, this is no basis for singling out the Charter. And then there were complaints, again Baroness Deitch and Lord Folkes, they expressed concerns about judgments by the European Court of Justice. But under this bill, under the government's own bill, Clause 6, it is only judgments handed down before exit day which are binding. And they're only binding up to the level of the Supreme Court. Judgments that are given by the Court of Justice in Luxembourg after exit date are simply not binding on our judges. It's up to our judges whether they follow what the Luxembourg Court may say in the future. And I emphasise a point I made in opening this debate, that neither Baroness Deitch, nor Lord Folkes, nor the Minister, or anyone else has actually given any examples of judgments given by the Court of Justice in Luxembourg on the Charter to which they take exception. Finally, Lord Cavendish of Furness told the House, and it was a very striking intervention in this debate, that the Good Samaritan, I hope I quote him correctly, the Good Samaritan did not need a bunch of lawyers to tell him what to do. I say to the noble lord, I say to the House, that unfortunately government and other public bodies often do need to be told by judges what to do. And I say to the noble lord, Lord Shinquin, that often Parliament has failed to protect fundamental rights. Without enforceable human rights, the victims of injustice and the victims of discrimination do and can go unremedied in the context of employment, equality, or property rights. And I say to the noble Lord Cavendish and others on his benches that if a Labour government under Mr Corbyn were to be elected, they will be glad of the ability of courts to listen to human rights cases to secure remedies against arbitrary state action. And they should think about that point, which I put forward as a crossbencher. And as I said in opening this debate, to exclude the Charter from retained EU law is unprincipled and it is unjustified, and the House has heard no coherent defence of the government's position. I do wish to test the opinion of the House.
The question is that Amendment 15 be agreed to. As many of that opinion will say content, the contrary not content, clear the bar. My Lords, there have voted contents 316, not contents 245, so the contents have it.